All right, good evening, everyone. We're going to get started now. Just to let everyone know, this event will be recorded. Thank you all so much for joining the JCRED 2024 Spring Symposium. We are so delighted to have you joining us this evening. My name is Brittany Cespedes, and I am the Research and Symposium Director. We also have on the Zoom with us this evening our Editor-in-Chief, Alex Snow.
Hey, everybody. As many of you know, my name's Alex Snow. Thanks for the introduction, Brittany. I'm the editor-in-chief of JCRED. We're really excited to have you join us for the symposium. It's titled The Fight Against Anti-Wokeism in the Classroom, the Legal System's Role in Maintaining the Status Quo. Because of the particular relevance of this topic in the current legal and political landscape, the 3L staff collectively decided at the beginning of this year that this would be a really interesting topic to solicit scholarship from for this year's symposium. So I really want to thank all of you for attending, as well as for our panelists for contributing their time to discuss their work in this rapidly evolving and very interesting area of law. Finally, I'd like to thank Brittany, who I'll now turn it over to, who worked very hard all year to put this together. So thank you, Brittany. And we're looking forward to everyone participating and learning more about this topic.
Thank you so much, Alex. So the Journal of Civil Rights and Economic Development, founded in 1985, is dedicated to researching and publishing scholarly works about social, racial, and economic issues in our society. As a student-run publication, we are privileged to collaborate within a community of intelligent, hardworking students, professors, faculty, scholars, and legal advocates who are just as deeply passionate about shaping our society's discourse. This year's symposium aims to highlight legislation seeking to influence how schools teach American history and addresses racial and LGBTQ+ topics. Education forms the cornerstone of good citizenship, enabling us to comprehend and engage with our surroundings, formulate societal laws, and question the status quo. And of course, we know that knowledge empowers, and controlling the historical narrative equates to controlling society's direction. For instance, numerous states are enacting bills opposing the teaching of critical race theory in schools. Critical race theory aims not to promote an anti-American worldview or induce shame based on race, color, or gender. Rather, it seeks to educate and shed light on the systematic racism embedded within various social institutions in the United States, such as the criminal justice system, the education system, labor market, housing market, and healthcare system. Another concerning trend is the push in certain state legislators for book bans on LGBTQ plus related literature. Such censorship inhibits students' understanding of the ongoing discrimination faced by LGBTQ plus individuals and can be very detrimental to the self-esteem and societal perception of LGBTQ plus students. In addition, diversity, equity, and inclusion programs that have supported historically underrepresented groups, fostered equitable environments, and cultivated cultures that promote respect, tolerance, and understanding for all are now being cut in both workplaces and educational institutions. Many scholars, including those on our panel today, have conducted extensive research to bring attention to these critical issues. The future of our society rests on each generation. And how can each generation tackle these issues if they are unaware that these issues exist? Shielding youth from these problems risks fostering a society where the struggles, growth, and ongoing efforts of marginalized communities are ignored. Understanding and empathizing with diverse experiences and viewpoints are vital for societal unity and equality. Exposure to various perspectives is essential for training future leaders who appreciate and navigate the complexities of our diverse society. Despite all the progress we've made so far, America still falls short for greatness for everyone. We need individuals like our panelists today who are committed to educating each generation and advocating for a society that ensures equality for all. Today, our 5 panelists will provide an overview of their papers centered on the development of these laws that are affecting minority groups. Now I will introduce our panelists. Today, we have joining us this evening, Joseph Kim, Community Partnership Fellow at Inner City Law Center, Kyle Reinhard, 2022-2023 CRT Ford Fellow at UCLA School of Law, Professor Taifha, Professor of Law at USC Gould School of Law and CRT Forward Project Director at UCLA School of Law's Critical Race Study Program, Professor Molina, Associate Professor of Law at Capital University Law School, and Professor Mitchell, Director of Michael A. Middleton Center for Race, Citizenship, and Justice, and Ruth L. Hilston, Professor of Law at University of Missouri School of Law. Thank you all so much for coming to speak with us this evening. And just to let the audience know, after each panelist presents, we will have a short Q&A session where we will be taking questions from the audience. So you can feel free to unmute your microphone at that time, or you can also feel free to drop questions in the chat box. So now we will hear from our first panelist, Joseph Kim.
Okay, hi everyone. My name is Joseph Kim. I'm a little nervous, my first time doing anything like this. So I'm currently in LA. I work as an eviction defense attorney, and it's been a really steep learning curve. So I really want to express my gratitude and appreciation to Brittany for her tremendous patience and just understanding and helping like organize all of this and answering all my questions, whatever time they may be at. So yeah, I hope you all can be gracious with me. And then I also wanted to preface this entire discussion by saying, let me share my screen. By emphasizing that I see myself like as a peer and not as an expert. And honestly, maybe not even as a peer, since there's so many people with so much knowledge and experience on this panel and in the audience. So hopefully not something like this that you see on the slide, not a vertical relationship, hopefully, as much as that can be on Zoom, but more of like this, where we're just talking to each other. I hope everyone can see the screen, otherwise this will be embarrassing. But yeah, and I think lawyers tend to be a little self-important anyway, so I hope we can engage in this together. And so in the spirit of that class, in the spirit of my paper, I hope that we can all be engaged in this project of collective learning. You know, I may not know the answers, and perhaps I will often not know the answers that might come up to questions in the Q&A, but I hope it can be an experience where we learn together and grow together mutually, and think through how we can constantly be in pursuit of freedom and liberation in our lives. So I just wanted to start with part one. My paper is divided into several parts. And so part one is focusing on desegregation and how this idea of desegregation in our schools was usurped by racial integrationists, such that racial integration became the one prevailing view of desegregation. And so the first part of my paper is tracing 3 cases to look at how racial integration became the predominant method of desegregating schools, American public schools. And so I'm looking at these 3 cases, technically 4, but I lump Brown and Brown 2 together. So Brown v. Board, San Antonio Independent School District, and then Milliken v. Bradley. And so Brown v. Board, I know Brown is often discussed in constant and close connection with racial integration, but I think viewing Brown as just a racial integration case is a very limited reading. You know, I think we can see Brown as a case about desegregation and not specifically about racial integration. And I think that difference is important. And I think racial integration is one way to desegregate based on physical skin color, but I think there are a lot of different ways to desegregate public schools, not just literal physical racial integration, right? And, you know, in Brown 2, the word integration doesn't even come up really at all. And so, you know, throughout the history of this case and throughout integration efforts in public schools, civil rights attorneys and legal strategy began to coalesce around racial integration as kind of the strategy for desegregating public schools. And then after Brown, and after we get, a decade or so of expanded civil rights, of desegregation efforts, of racial integration efforts, we see Earl Warren retire in 1968, and Richard Nixon appoints 4 moderate to conservative, honestly, a little bit conservative, hard conservative, Supreme Court justices by 1973, right? And that is kind of troubling. And so we get San Antonio Independent School District versus Rodriguez in 1973. And this is a 5-4 opinion in favor of the state of Texas. All 4 Nixon appointees would vote in favor of the state of Texas, right? And so, from 1954 up till this point, we have a lot of affirmation of racial integration efforts, right? And so I see that as, encouraging to plaintiffs who are bringing these cases, right? And so as the court is continually validating them, I'm imagining plaintiffs trying to advance broader visions of what desegregation can look like, right? It doesn't have to just be about racial integration, physical racial integration of public schools, right? And we see an example of such a case come out in San Antonio Independent School District versus Rodriguez. And this argument has a potential to crack open the relationship between race and class, because we see wider school districts are receiving so much more funding, right? And unfortunately, the court shuts this down. Racial integration, they say, is the only strategy of desegregating that the Supreme Court is going to recognize. And then we get to Milliken, right? And this is, again, a 5-4 opinion. And again, all 4 Nixon appointees are voting in favor of the state. And so we see this 1-2-3 strategy, right? Earl Warren, there's Brown, racial integration, that's how we desegregate schools. San Antonio Independent School District, let's kind of push the boundaries and advance a different method, maybe challenging race and class instead of just physical racial integration. But the court strikes that down. And once there's no other alternative but racial integration, the court kneecaps racial integration in Milliken, where it strikes down any inter-district remedies for desegregating schools. And so I also, in the second part of my paper, wanted to focus on the limits of racial integration, right? And so we see a couple limits here posted in the slides. And so I really wanted to emphasize that segregation and Jim Crow in America wasn't just about skin color, right? It's about power and hierarchy. And racial integration, it tends to focus a lot on skin color. And if we focus only on skin color with an issue that is so much more than that, it's not just about skin color, then we fail to completely capture the problem and find remedies to that problem, right? And so when Black parents began seeing how racial integration isn't leading to the outcomes that had been anticipated, these Black parents are advancing alternative strategies to educate their children. But these civil rights attorneys are so dead set on racial integration because that's the strategy that was authorized by the court. That's the strategy that's tried and true, right? And so we see a lot of harms that come with racial integration, with shutting down local schools and local communities. A lot of Black schools were shuttered down, Black principals, Black teachers were fired, right? White families would never allow Black people to have authority over their children. And so this mass firing of Black leaders was so severe that, its impacts were felt well into the 21st century, into the 2000s, right? And so even in integrated schools, we're seeing strategies like tracking, right? Where you're dividing students based on their ability, right? Tracking and punishment to separate Black children from white children, even within the same school. And that's perpetuating these myths of incompetence and inability and lack of achievement that continue to perpetuate today, right? This focus on skin color is failing to consider how just moving Black children into white schools is not going to eradicate the anti-Blackness that's in those schools, right? Segregation is not just about skin color. So any strategy that focuses just on skin color is going to be inadequate. And so I wanted to express in this paper how, you know, a politics of inclusion is the politics that's emphasized when we're looking at physical racial integration. And there's so many limits to just focusing on inclusion and assimilation into white society, right? As I was saying, like, racial integration it focuses on skin color, just physical skin color, right? Instead of the actual meaning of Jim Crow and segregation, which was about power. It was about more than skin color. And so I think, you know, in looking at and evaluating racial integration as a strategy for desegregation, I wanted to point out how it's limited, right? It's one way to desegregate, but I think it's an incomplete way to desegregate public schools. I think we can have a broader vision and interpretation of the court's mandate in Brown to desegregate public schools with all deliberate speed, right? Racial integration is not the one way. And so in this third part, I wanted to advance what I am seeing as this new, you know, potential, this new understanding of desegregation, right? Looking beyond just physical skin color and looking to the political material salience of race, right? Skin color is not just physical difference, it has relevance and has material impact and has material consequences in our lives. And so, you know, we talked about how the overemphasis on race as skin color was harmful, but I think the remedy is not to ignore race altogether, right? I think we can still be race conscious, even if we're not focusing on mere physical difference, right? Race is a social construction that's been made salient by history and culture. And when we focus on the history and culture that made race salient, we can still be race conscious, even if we're not necessarily looking solely at physical skin color, right? And so I wanted to focus on the example of Black people, of African-American people in this country, right? History, I think, often tends to portray Black people as subjects or passive recipients of, you know, things that are being enacted on them when that couldn't be further from the truth, right? Black people have long been refused to be defined and bound by the terms of white supremacy, and Black people have always been active agents of change, of freedom, of progress in this country in the face of anti-Blackness. And it's long been the function of white supremacy to just snuff out and obscure these acts of resistance and snuff out these pursuits of liberation. You know, and to be Black in America is to be part of this legacy of resistance and struggle for freedom in spite of, right? To be Black in America is to be held together not just by skin color, but also by a culture and history of liberation, of striving for education, right? Blackness is not just about skin color, but it is also about that legacy, that political orientation, that practice, that pursuit of freedom in spite of. Right, we see in history plantation owners making every attempt to prevent Black people from learning to read, to write, imposing strict punishments, but still Black people are finding and actively seeking out education using a variety of subversive means, right? In cellars, in forests, in caves, using the natural landscape to engage in subversive ways of educating themselves and pursuing this education, right? Researchers and archaeologists in America have found remains of graphite pencils and writing slates in cabins where enslaved people have lived. And so through education, Black people have always subverted white people's attempts to prevent them from defining for themselves their own experience. And, you know, I think it's important to focus on this legacy of subversion and this refusal to be bound by the terms that white people set out for them. And that's a thread that spans from colonial America to today. And I think there's a lot of power in focusing on this mass resistance, right? It's not a focus on physical skin color. It's a focus on the collective practice and ideology, the pursuit of freedom, pursuit of education. And I think in today's current climate, where they're striking down, you know, any attempts to, you know, integrate and things like parents involved, looking to this practice, this race consciousness in ideology can be a way forward. And so the final portion of my paper focuses on the Freedom School example, right, in Mississippi. Mississippi denied Black people the opportunity to think for themselves about the conditions of their lives, about how they came to be where they were, and how that might be changed, right? And the organizers of the Freedom Schools were not oblivious to the power of a curriculum that is grounded in radical Black history, right? And so from the very inception, the Freedom Schools were about defying the Mississippi government and refusing to abide by the terms it set out for the Black community. And it took a different approach from racial integration, right? Instead of pursuing litigation and legal strategy, the Freedom Schools grounded themselves in spaces of Black self-determination. They were focused on building up and strengthening Black communities where they were. They operated outside of the legal system and worked to destabilize the white supremacy that was ingrained and forced upon Black communities. And it did this through a practice of collective learning, right? They were a means, the Freedom Schools, of consciousness raising for everyone who attended. And their entire point was to create an educational experience that was focusing on desegregating the curriculum, not desegregating schools through literal, physical, racial integration, but desegregating the curriculum to challenge a politics of inclusion, to mobilize young people to become agents of change and work towards creating more liberatory institutions that are actually addressing and recognizing the conditions of Black people in America. And so, yeah, I think I went over, but and I'm not even sure I did that properly. I feel like it's hard for me as someone who wrote this to break down what's important and what's not. So I hope that message came across. But yeah, I'm totally open to any feedback and questions now.
Thank you so much, Joseph. That was actually really wonderful. I really love the PowerPoint. And now this will be the Q&A session. So if anyone would like to ask a question at this time, you can feel free to unmute yourself, or you can put a question inside the chat.
Hi, Joseph. I have
Hi,
a question for you.
Yes.
Good to see you.
You
And I think you also did a phenomenal job. My question for you is, how does your paper engage with the current anti-discrimination frame of strict scrutiny, right? Because if you're advocating for a different sort of approach that involves race, that's already going to trigger strict scrutiny. So, and then from there, we're probably not in a good space, right? So does your paper engage with that at all in advocating for a different level of scrutiny when there is any sort of race conscious remedy that is applied to, in this particular case, racial integration in schools, or desegregating schools in a different way?
Yeah, for sure. I was thinking about that a lot as I was writing as well. And my take has kind of been so much of the racial jurisprudence in this country is focused on race as skin color, right? On physical difference of race. But what I'm hoping to get across in my paper is that there's a lot of different ways to engage race that don't necessarily invoke physical difference, right? And so if we're looking at the pursuit of freedom, the pursuit of education, the subversion, and the subversive methods that enslaved Black people used to educate themselves, that is an ideological race consciousness that's being race conscious about history and including that, but it's not premised on skin color, right? And so I think for me, that's a way to maybe get around the court's racial strict scrutiny regime, because we wouldn't be invoking skin color when we're doing it. We would be invoking this ideology. And I don't think that there's been, correct me if I'm wrong, I don't think there's been like a Supreme Court case that imposes strict scrutiny based on racial ideology necessarily.
Thank you.
So now we will move on to our, thank you so much, by the way, Joseph. We will move on to our next panelist. And if you do have any more questions for Joseph, you can always feel free to just put them inside the chat. And if we have time, we can definitely circle back to them. So our next panelist will be Kyle Reinhard.
All right. Thank you so much, Brittany. Hello, everyone. I wanted to start by expressing my gratitude to all the folks at the Journal for organizing this event and for providing a forum for discussion and writing about this very unfortunate, upsetting, kind of always fascinating subject. Like Joseph, this is my first symposium as a panelist. 4 years after the start of COVID, I have finally turned on the blur function on my Zoom background. So that you don't have to see my dirty kitchen back here. I'm trying to be professional. In any event, hopefully I don't stumble over my words too embarrassingly and go eat them. So I'll start by introducing myself just a bit. I got my JD from UCLA Law in 2021, where I was a proud part of the critical race studies specialization. A little over a year after graduation, roughly from fall 2022 through fall 2023, I was so happy and thrilled to get to return to UCLA as a fellow with the CRS program, where I work very closely with Taifha, who you'll hear from later on, with the CRT Forward initiative. So as part of this work, Taifha and I have read through hundreds of federal and state bills. Sorry, there's a flying dog behind me. Federal and state bills, and scrubbed through the meeting minutes of many chaotic school board meetings. And I know she'll be presenting some of the more empirical findings from the tracking project. I'm sure she'll have a lot of good stuff to say. Along with this sort of more empirical work and cataloging all the new measures that were coming in each and every week and month, I was also given the opportunity to work on a law review article of my own, which ultimately is what turned into the piece that's appearing in the symposium issue. Basically, I was given a pretty open-ended kind of general subject matter prompt, which the larger faculty subcommittee was interested in. Basically, it was kind of the anti-racist campaign and the First Amendment, or racing the First Amendment. And of course, that's its own second level of open-endedness, since First Amendment is a huge subject, each with its own vast body of case law. There's 6 clauses: the right to petition the government for redress of grievances, the right to peaceful assembly, the right to freedom of the press, the right to freedom of speech, obviously. And this is what most people probably think of as like the bread and butter of First Amendment law. Prohibitions against vagueness, overbroad laws, or viewpoint discrimination. And I'd say when I started my research, the speech clause certainly had the most well-developed body of sort of scholarship in relation to anti-CRT stuff, and I suspect that continues to be the case. But as I grew sort of more acquainted with the various anti-woke strategies that were being employed in the accompanying rhetoric, and I don't know, maybe out of a desire to zig when everyone was expecting a zag, I became especially interested in how the first 2 First Amendment clauses, the religion clauses, might bear on the movement. So that's, of course, the right to free exercise of religion, and then especially the right to be free of government establishment of a state religion. So that's kind of a long-winded way of getting into the topic of my article, which is entitled Myths and Magical Thinking, American Civil Religion, the Establishment Clause, and Codified Irrationality in Anti-CRT Measures. So with the remainder of this time, I guess I'll try to provide a little teaser for what I came up with and sketch out how the arguments are structured generally to give those of you who might want to read it in full a sense of how it develops. It's fairly long and kind of convoluted, hopefully not too convoluted, and I apologize for those who had to edit it, all footnotes and stuff like that, but I'll try my best to sort of make it sound like an enticing read. I'd say in a very broad sense, my goal was to try to kind of find a continuity between various manifestations over the last almost 100 years exactly, of what we might call like a culture war, and especially those sorts of culture wars that are religiously motivated and have been waged using the law specifically. So I'll start with sort of just the very first line of my abstract. It says, some experts have called the recent controversy surrounding teaching critical race theory in K-12 public schools a, quote, modern day Scopes trial. And so for those of you who aren't familiar with Scopes, it was a 1925 case, very highly publicized at the time. It was once referred to as the trial of the century, of course, although I've come to find out that that's a designation that's been used quite frequently, including in a case the year before. So I don't know how meaningful it is to have been the trial of the century, but it's a very famous case, starring big shot attorney Clarence Darrow, arguing for the defendant John Scopes, who was a high school biology teacher, was fired for teaching the theory of evolution. It's a very interesting case, very colorful, goofy history, very much worth reading about. There's a great book about it that I drew on a lot for the sections about Scopes called Summer of the Gods, which is written by a law professor named Edward J. Larson. But okay, so basically Scopes has been referred to as the monkey trial, where regarding the state of Tennessee's monkey law. Here's the text of the Butler. It was the Butler. It shall be unlawful for any teacher in any of the universities, formals, and all other public schools of the state, which are supported in whole or in part by the public school funds of the state, to teach any theory that denies the story of the divine creation of man as taught in the Bible, and to teach instead that man has descended from a lower order of animals. What was so striking to me while researching Scopes was how nearly identical the anti-evolution rhetoric in the 1920s was to current anti-CRT rhetoric. I guess perhaps that wouldn't be surprising to people of a certain generation. I was someone in high school in the early 2000s, and there was at that time there was a resurgence of anti-evolutionism in like the intelligent design movement, which I actually discussed in part 3 of the paper. But to me, it kind of seems a little quaint to think of the theory of evolution as this sort of threat to national security, which is something people claimed at the time. I was, scrolling through newspaper clippings, seeing stuff like the Darwinian theory represents man is reaching his present perfection by the operation of the law of hate, the merciless law by which the strong crowd out and kill the weak. It has led Germany into barbarism. These teachers are surreptitiously imposing the anarchistic, socialistic propaganda of evolution into the minds of children. It's an international Jewish Bolshevik Darwinist conspiracy. It's this overblown rhetoric that has really reappeared in these new anti-CRT laws. Compare that with what Trump said when he was announcing the executive order 13950, which debuted the divisive concepts boilerplate laws. Called critical race theory toxic propaganda, ideological poison, which has motivated left-wing mobs to tear down statues of our founders, desecrate our memorials, to carry out a campaign of violence and anarchy, which is designed to overthrow the American Revolution. It will dissolve the civic bonds that tie us together and destroy our country. So I guess the central claim of the article is not only the anti-CRT rhetoric sort of mirrors that of anti-evolution, but that this is so because anti-CRT, in a very meaningful sense, is itself a fundamentally religious worldview, even if you strip it of specifically religious language. And I think, as we all sort of have watched in horror over the last decade or so, or maybe 2 decades, given the steady ascendancy of, white Christian nationalism or Christo-fascism, or it's felt especially important to me to sort of notice parallels between these sorts of movements in order to find ways to identify when something that's calling itself a purely political movement, as perhaps an anti-CRT proponent might put it, when it's operating as something like an authoritarian religious sect. There's no such thing, as a political establishment clause, but perhaps this is exactly what the establishment clause is sort of meant to prevent. It's these sorts of behaviors by the state. In a 1968 case, Epperson versus Arkansas, which is the first case that the Supreme Court ruled on laws like the Butler Act, it was struck down. And there's a quote from Justice Fortas that I like. He says, "The overriding fact is that the law selects from the body of knowledge a particular segment which it prescribes for the sole reason that it is deemed to conflict with a particular religious doctrine." Even aside from the overt reference to the Book of Genesis, it's an establishment of a religious worldview to sort of legislate as if accepting the truth of the theory of evolution per se conflicts with the possibility of a divine creator. Brittany, as you mentioned at the outset, critical race theory need not be this sort of anti-American, anti-patriotic framework, and sort of premising these laws as if that is the case is no different from establishing a worldview similar to sort of a religious worldview. Children can believe in evolution and their religion, and they can learn about systemic racism and still believe it's important to be a patriot. And sort of when you say the opposite, that's sort of establishing a religion. Obviously, the paper goes, quite often several different directions, maybe to its detriment. But as I try to summarize it any further than that, that's kind of where I'm at. If anyone wants clarification about literally anything I've said, I could go into a little more detail about that, and hopefully I sound okay as I'm doing it. Thanks.
Thank you so much, Kyle. We'll open it up to Q&A now. If anybody has any questions or would like to unmute themselves, and I can just go first, just to give everybody else time in the meantime. But I know in your paper, like you discussed how the anti-racist curriculum promotes an orthodoxy of magical thinking. Would you be able to just like explain that to our audience briefly? Because some people haven't read the paper. So would you just be able to just explain that briefly to the audience?
Yes,
I
absolutely.
found that pretty interesting.
Let me pull up sort of my favorite frame for it. So basically, it's something I call in the paper the aberration. Basically, and Taifha would be able to speak to this as well. Basically, every anti-CRT law kind of, if people could describe it as, oh, we're still teaching all of these things. We still teach about slavery. We still teach about Indian removal, Japanese American internment, stuff like that. But the problem is laws like Texas's 2021 State Bill 3, it demands that those things be taught, but they can only be taught as sort of a deviation from the authentic American tradition. And so that's sort of one expression of it. Sort of does it's in a sense a magical thinking to codify the definition of something as being something that it's not. Another example, there are a few laws where it's made illegal to discuss the concept of systems, not even systemic racism, but systems, and what is a system in this sense, but just a series of causes and effects that sort of add up over time. If you deny the relevancy of certain causes as producing certain effects, you're demanding that miracles be taught. And there's actually kind of a fun literature from kind of early law review articles talking about miracles and how we, in the law and science, stuff like that, we have to proceed as if causes invariably produce effects. And when we don't, that's something that I call magical thinking in the article.
Thank you. There's also another question in the chat. It says, hi, Kyle, as this field develops, which states, if any, are you personally keeping your eye on for anti-CRT legislation?
Well, and Taifha definitely can second this, I'm sure. Something I was shocked, just being someone who looking at the laws every day, is that it's kind of happening everywhere. When I stopped, there was only one state which had not passed a law or introduced a law. And of course, purple states are sort of the classically divided states, that you're more likely to get a law passed in a purple state or introduced in a purple state. And that makes sense. So yeah, I mean, I guess I would say just the purple states. I think they're the ones who are sort of finding the most political purchase there. But yeah, I don't have any on the horizon.
Thank you so much. So if you all do, oh, Professor Chu, do you have a question as well? I saw your hand was
Yeah.
up. Okay.
Hi, everybody. I love seeing everyone, and this is actually such a little mini reunion of everything Ron Brown, but I'm not going to go into all of the many folks that we're bringing back together in this space. But first, I hit send a little bit too soon. I wrote the question for Joe, and then I actually forgot to add in the question for Kyle. So let me start with the question for Kyle first, which is, I'm curious if you could define for us what you mean by religion. I kind of hear, I think, a couple of different ideas or definitions of religion that were in your presentation. I was wondering if you could help us, and it could be multiple ways that you're invoking religion here. And then, Joe, you see my question in the chat, so thank you.
Yeah, thank you for that question. It's there's some great stuff in the literature too about how some people believe that, you know, for constitutional purposes you cannot define religion because even making a definition at all sort of excludes some possible conception of religion that could come into existence tomorrow. And so there's these, you know, there's various ways of defining it. There's I'm trying to think if there's one that I specifically settle on. The thing that I use in the paper as just sort of something to show that you can take seriously the idea that something like white Christian nationalism could be its own religion is that there is a sort of a sociological concept of just the American civil religion. And that's something that, you know, we might think about as, you know, we like to salute the flag and we like to, you know, we have pictures of the founders on our coins and stuff like that. But the Supreme Court has said, I'm trying to remember the case, but it was Justice Kennedy, and I think it was in 1992. He said, you know, you can't just call something civil religion, and that makes it okay to do things that would violate the Establishment Clause under a non-civil religious definition. And so the Supreme Court has sort of indicated that there is a line there. And I think while sort of wrestling with the difficulty of defining religion generally, I sort of just come out on the side of, you know, there is a version of American religion that is meaningfully religious in the sense that it is operating like an authoritarian religious cult kind of a thing, or a religious sect of some kind. But so yeah, it's, I guess the cop-out answer is that the paper acknowledges that it's kind of difficult to define it, but that there is, you know, literature going back and forth on that kind of thing. Thank you.
And Joseph, I don't know if you saw, there was a question for you in the chat. I'm not sure if you'd like to address that now or.
Okay, we can move on. I'm typing out all my answers.
Okay, okay. Got it. No problem. No
stuff, so okay.
Okay. So then now we will, thank you so much, Kyle, for your presentation. We will now move on to Professor Taifha.
Awesome. Thank you all so much. And thank you to my fellow UCLA alum, Kyle and Joseph, for their phenomenal presentations. I am also an alum of St. John's undergrad, so this feels like coming home in a lot of ways, and have found a tremendous mentor in Professor Chu. So I want to thank you for your support, Professor. And I want to thank you, Brittany, for getting us all together here, because this takes a lot, right? And so I want to give you your flowers while you're here. I am Taifha Alexander. I'm the CRT4 project director at UCLA School of Law, in addition to holding a bunch of other positions. I'm here to talk to you about not specifically a paper per se, but the CRT Forward project, which is a data, policy, and legal analysis tool that tracks, identifies, and analyzes official government actions aimed at restricting access to truthful information about race and racism through a campaign to reject critical race theory. And so you might be asking yourself, well, what is critical race theory? And so this definition was created and generated by myself and my colleagues at UCLA law, and really builds on the concepts and tenets of the theory. CRT itself emerged in the 1970s and 80s among law professors to better understand how racial inequality continued to persist even after monumental civil rights advancements. What we now know is that these scholars not only discovered the how, but have also provided frameworks and strategies for liberation and racial progress through their suggestions for the what next. And this is what makes critical race theory unique, right? Despite what extremists might otherwise want us to believe, critical race theory is a theory, but also a practice that helps us understand how race and racism shape our laws, policies, and structures, despite civil rights advancements, with a hope to change the laws that have produced racial inequality. And so one critical component of CRT is the practice of understanding how the past has contributed to our current lived experiences. So to understand the now, we must first revisit the recent past of summer of 2020, right? What was abundantly clear after the summer of 2020 and the massive public response to the murder of George Floyd was that the public was concerned about how existing practices and procedures may have been reproducing or entrenching racial inequality. So questions of structural racism and the demand for attention to equality featured prominently in public discourse and led to some of the most widespread public mobilizations since the civil rights era. And so in the context of the twin global pandemics of racism and COVID-19, as well as hotly contested national elections, government agencies, educators, and private businesses all launched initiatives grounded in anti-racism with varying levels of potential for systemic change, right? So the anti-lynching bills were reintroduced into US Congress, but then the NBA changed their floorboards with terms and phrases about commitments to justice that I haven't seen. But there was this nascent but powerful movement among educators to tell a more accurate and full history. And some folks resisted these initiatives and sought to deflect these demands for reform and commitments to anti-racism. Conservative media outlets denounced what they characterized as extremist critiques of racism, labeling anti-racist critiques as racist themselves, which goes back to what Kyle was talking about of how terms are recodified and upheld as something differently than what they mean. And so these activists published articles and appeared in numerous outlets denouncing CRT as embodying anti-racist analysis and urged the government to act against the promulgation of these ideas. And so the former presidential administration was especially susceptible to anti-CRT sentiment from these activists. And so the introduction of the now rescinded Trump administration's Executive Order 13950 in September 2020 squashed the potential of anti-racist interventions and ushered in a multi-year-long disinformation campaign. And this disinformation campaign involved co-opting, redefining, and repackaging CRT in a way that displaces the true definition of the theory to allow for a mischaracterization of not just CRT, but any and all concepts that are related to it. So faculty and staff of the CRS program realized that there was some significant gaps in information about the assault on CRT. Namely, there were many organizations and groups doing the valuable work of identifying anti-CRT measures at either the local or state and federal levels. But there was so much more that could be done. So up until the launch of CRT Forward, there wasn't really much information about what was going on in states outside of South Carolina, Texas, Georgia, and Florida. And as a result, only part of the story was being told. And because only part of the story was being told, the value that CRT Forward adds is telling a fuller, more accurate story of the pervasiveness of the assault on CRT. And so the tracking project is one of 3 critical components of CRT Forward, and it is an up-to-date, easily accessible clearinghouse of local, state, and federal government activity aimed at limiting access to truthful information about race and systemic racism through a campaign to reject critical race theory. So this anti-CRT activity, as we defined it, includes local, state, and federal level actions that determine which type of institutions are being targeted. So are we thinking K through 12, or are we talking about state and federal government agencies? We're also looking at the type of conduct that's being prohibited or required, like, for example, teaching or curricular surveillance. We are interested in the specific features of each measure. So like, for example, if CRT is specifically mentioned, the 1619 project, or certain divisive concepts from the executive order are being invoked, we're also interested in that information. And so on this database, you're able to search over 700 different identified anti-CRT measures to locate activity that might be relevant to your interests and research needs. And I know there was a question earlier about focus points and what's the next area of focus. And so you're more than welcome to just Google UCLA CRT forward, and you'd be able to interact with the data that we have there. And so just some numbers before I end really quickly. One of the main goals of the tracking project is to provide academics, journalists, researchers, organizers, advocates, parents, and those who are just committed to truth and justice with a unique resource to better understand the scope and trends in the recent local, state, and federal anti-CRT measures aimed at restricting access to truthful information. And so one of the most alarming trends that we've found is that there have been 783 different anti-CRT measures that have been introduced across 49 states at the local, state, and federal levels. We've also realized that about 90% of the measures target K through 12 education, and that for every one rejected anti-CRT measure, between 4 and 5 have been enacted. And so that puts a whole new spin on the idea that a lie can travel the world before the truth has an opportunity to catch up. And so what we did while under Kyle's leadership was write and publish a report that identifies some of these trends. And going forward, we are planning to publish a model measure that would allow for legislatures and other government agencies, colleges, universities, anywhere where there have been attacks on CRT, diversity, equity, and inclusion, social emotional learning, the whole gambit, to be able to introduce a measure that allows for the true telling of critical race theory, what it means, and how to implement such policies. Also thinking about highlighting additional data on our website, which would include a litigation table so folks can track what's being challenged, where it's being challenged, and to create data analysis points on the litigation itself. So I will stop here and answer any questions that anyone might have.
Thank you, Professor Taifha, for the wonderful presentation. I can go first with the question. So I know you mentioned that part of the story is being told in regards to CRT. What do you think is like the primary reason that people feel threatened by CRT in general?
It's a great question. And I think the answer can be found in looking back at the summer of 2020, right? About how across race, across generation, across class, across identity, people were gathering together and demanding that there be systemic change to address these systemic injustices. And for a lot of people, especially those who would benefit from maintaining a status quo, that was scary, right? They didn't want that to happen. And so critical race theory, which it breaks my heart because when I first discovered critical race theory as a 3L at Georgetown, it finally provided language for my lived experience. And so there's something so poetic about critical race theory that explains this exact moment that we find ourselves in, right? Professor Kimberly Crenshaw's idea of race reform and retrenchment demonstrate for us that whenever we see any sort of movement towards civil rights advancements, there's always a valley of civil rights regressions, right? And so the poetic thing about that theory, though, right, is the idea that there's always hope on the horizon, right? It's never that we're consistently living in this valley or this regression, but there is a possibility for hope, but that is dependent on the folks that we just heard from today, right? From Joseph, from Kyle, from the folks that we're going to hear from in a few moments, and ensuring that there are people ready to be at the mantle to ensure and to entrench racial justice.
Thank you. And I see we have a couple of hands raised, so any of you can feel free to just unmute your mic and go.
Thank you, Brittany, and thank you to all of our presenters so far. I'll be very quick because I know we have a few questions lined up, but I just wanted to add to your answer, because I think a part of the the villainization and this false equivalence of CRT with being, indoctrination of our children. You actually had a slide. I know you don't have time to explain every little thing on the slides, but you had a tweet, I think, from Christopher Rufo, who is one of the main people who popularized and really intentionally, and I know you know this, but I'm, for everybody else, this was really in large part the work of this particular guy. And the people surrounding him, because critical race theory, and as you brought up Kimberly Crenshaw, and I saw Cheryl Harris, who authored Whiteness is Property in your presentation as well. These authors have been writing about this stuff for a long time. And just for all the 3 Ls, or all the 2 Ls who are going into the 3rd year this upcoming year, St. John's actually just taught the first critical race theory course for the first time with Professor Mark Niles, who is excellent professor. So I just highly recommend to all the 2 Ls in the chat, if you get a chance to take critical race theory with Professor Niles next year, you definitely should. It's an excellent course, and I learned so much, and much of what you said, it was, taught in that course. But that tool that, the CRT forward, that tool, that is incredible. And it actually wasn't brought up in the class. So I'm going to email Professor Niles after this and let him know about this, and that we are working with you to, to have you present for the journal. So thank you very much. But the rest of you can ask questions. I think Julio may have been next, so I don't want to talk all night. So thank you again.
No.
Yep. Hi. Thank you so much for presenting, Professor Alexander, and for all the presenters before. One of the questions that I just had was, do you think that it will establish more legitimacy if critical race theory is taught like throughout more like higher school institutions? So at what Alex was saying, like the fact that St. John's now had a CRT course, I'm not sure like what the numbers are in terms of which universities are like teaching students like on the subject, but maybe like that can be one way to really like highlight how important it is, especially since there's a lot of pushback, it seems, and what Kyle also touched on before, from like in schools that are K through 12, in having like CRT programs. Like that's what politicians are taking issue with. But I mean, I think if we show like a lead by example approach, maybe, I don't know. So I was just wondering your thoughts.
Yeah, thanks, Julio, for the question. I think originally and Kyle and I have had lots of conversations about this, so I'd be interested in hearing his thoughts as well. But essentially at the beginning, when the attacks first started, everyone brushed it off, right? So everyone's like, oh, Trump doesn't know what he's talking about when he's talking about ban. Like it was like a knee slap kind of reaction. And that was a mistake. That was a huge mistake, because that would have been an opportunity for litigators, for scholars, for everyone committed to social and racial justice to step up and say, hey, this is CRT, this is what it is, this is why it's important. I think also what we saw was that there was this reaction, this automatic reaction among folks in K through 12 schools to say, oh no, we're not teaching critical race theory. That's not what we're doing here. And while that might have been true to some extent, I'm not completely on board with CRT wasn't being taught in K through 12 schools. But what that did was that distanced critical race theory from schooling in a way that made people think like it's not okay to be done, right? And so I think teaching it is important. I think being knowledgeable of it is important. I think there's also this rhetoric out there that learning about critical race theory is like un-American in some way. And I think that couldn't be further from the truth, right? The idea of engaging with and dissecting history and lifting up every crevice of how race and racism has been used to create differences in treatment of people on the basis of race is something that is extremely American, right? And the censorship of this is what is un-American. And I think that not enough people have gotten behind that. Hope, do you have a question?
Less of a question, more just of a general comment. I just want to thank you so much for all the work that you do, especially compiling all this data. I actually come from one of the cities that's mentioned in one of these maps. And it's really unfortunate and really kind of shameful on my city, but it's nice to be able to have somebody pointing this out and saying like, hey, these people are doing this. They're trying to get rid of curriculum where I lived in that city my entire life. I'm a product of learning this kind of stuff. And I agree, it only makes for better people and better students. So it's nice because at least from my town, like it was just a school board decision that was kind of hush hush in the dark until people like you like started pointing it out and saying, hey, this is messed up. This is what's going on. So thank you so much.
Absolutely. I'm originally from 15 minutes from St. John's campus. And so when people when people in New York are saying this isn't an issue, it's important to uplift the fact that, you know, something has been introduced and that at the state level, and that has a chilling effect on teachers and educators. Or if you're in Smithtown, there's definitely an impact on your children and what they're learning. So thanks for that. Lauren?
Hi, you kind of answered my question, but I'm still going to ask it. I know there's like 4 other questions in the chat, but I know most of the CRT bans are focused on K through 12 schools. And so, and they've had a large effect on that, but I wanted to know if like from your research and what you found, has that had a ripple effect on institutions of higher education? And if so, like how has that affected those conversations in those institutions?
Oh yeah, for sure. So Kentucky recently dismantled all diversity, equity, and inclusion offices in their state. Florida has done the same for state public universities. And so this isn't just limited to K through 12, even though the overwhelming amount of measures that we have found focus on K through 12. And, you know, the reason for that, I think, is that if you're able to control, and this alludes to what Brittany said, if you're able to control what students can learn, you're able to control the future, right? And so limiting students from having access at any level from K through 12, K through 16, is going to limit those students, the next generation of thought leaders and scholars, from being able to address some of the most important social and racial justice issues of our time. And I know Professor Chu had a question that relates to the data in a similar way. And I just wanted to say yes. So we're also looking at efforts that target private businesses, right? So Florida is famous for this in our just like CRT forward space, in that they've attempted to pass measures that would limit how a board of directors would be able to have their it's called social equity measures. So essentially saying you're not going to be able to look at diversity, equity, inclusion in your private business space when you're thinking about board of trustees members. There's also targeting the private businesses to limit trainings and things along those lines as well. But these sorts of measures are really specific to Florida. Haven't really seen them outside of Florida as much, even though there might be some data in other states as well. And I know that I've went way over time, so my apologies, Brittany, but I will respond to text-based questions in the text or in the chat.
No problem, and thank you so much for the insightful discussion. I really appreciate it. So we will now move on to Professor Molina.
Good evening, everyone. I've really enjoyed everyone's discussion and presentation so far, so I hope I add to the conversation. And of course, thank you, Brittany, and other members of the journal that have organized this sort of wonderful and timely conference. So what I want to talk about is, was I unmuted at the same time? Okay, anyway, so what I wanted to talk about is this collaborative model that here at Capitol that we adopted over 3 years ago. And what I hope to do is to sort of demystify some of what CRT can look like in an educational space. And of course, I'm going to be talking about the law school space and more specifically within the first year curriculum. So I want to provide a bit of a roadmap of the paper itself and sort of what it is that I hope to accomplish. So I want to talk about this collaborative model that allows both faculty, students, staff, and administrators to grapple with ideas, to critically examine perspective, and to test assumptions, as well as to facilitate meaningful learning and empathetic classroom discussion. As you can note, what is absent from there is being divisive or polarizing or wanting to cause harm to any one particular group of students. I think that CRT is a wonderful educational tool that is so important to so many students, and especially within the legal context, because you can really focus on the way in which our laws and policy, both present day and historically, has impacted many communities, in particular our more subordinated ones. So if I provide, I want to start with like the big picture of what it is that we do at Capitol. So this project started in the fall of 2021, and if you can remember, it was after that summer of such unrest, and on top of that was a pandemic. So most of this learning was taking place online, but the faculty got together and we decided as a point of value in coming together to address some of the many issues that we confronted in that summer, that we provide a way to educate our students in a way that's meaningful. So we started in the fall of 2021, and we actually invited the author of The Color of Law, Rich Roston, for a virtual visit to the law school. It was a community-wide event, and it was one of our more highly attended events. And it was a wonderful one because we talked about his book. He was very interested in speaking to many of our students. So sort of cued the interest in the book itself, in the discussion. And then later in the spring term, all of the property professors agreed to incorporate the color of law within the property curriculum, specifically when they talk about racialized zoning and racially restrictive covenants. So each property professor, there's about 3 of them, in their own way, integrated the book into the classroom, and they specifically integrated chapters 3, 5, and 12. Some of them did an additional chapter, 1 or 2, but we ensured that at least these 3 chapters were covered. So that coverage took place side by side with their discussion of, what is discussed in property. And then the students were also encouraged to watch a documentary. So that took place within the property curriculum. The law school, for our first year law students, we have an ICC course, which is largely skills-based. So it has a focus on sort of a practical component as well as professionalism. And one of the learning outcomes that we have at the law school is for cultural competencies. So the ICC professors, they all agreed to give me space. So I want to give you not just the big picture of what it is that took place, but the involvement of the faculty. We have more than half of the first year faculty participating in the project itself. You had over this 3-year period, over 500 students read The Color of Law. So the hope is that in this collaborative model, we demonstrate that Capitol, through its students, through its faculty, through its administrators, that this is something that we share and that we value. And I also have to add that each year, the dean of the law school has gifted each and every student a copy of The Color of Law. So it's this collaborative process. Now, my specific role in this is that I come in, I run the ICC session itself. And we have 3 sections of 1L students, 2-day, and an evening section. And so I use a hybrid approach to learning. So there's always a component that students do on their own, and then we come together and we discuss. I often facilitate that discussion with what I call a module. And if you can see the module itself, it looks like any one of my modules. So this is not an aside, an extra project. This is directly related to the substantive learning that is taking place across at least 2 to 3 of their classes. And I also connected with the specific learning outcomes. So I have a number of like content dependent questions where the students see the questions in advance. They come together in small groups and they discuss each one of these questions, and they're writing the group's consensus on a little colorful Post-it note. And that is when I think the best learning takes place, because the professors, the faculty are sort of removed out of the learning, and the students are conversing and learning from one another. And it's towards the end of the spring term, so they're very tired and very starting to shift their focus to finals. And you see them reading out loud to one another. You see them saying, wait, did it say this? What about that study? What about that case? And so the learning is just taking place. And so after a short period of time, the students then place their Post-it notes in a designated area for question 1, 2, and 3, and so on. And then I read the group's response, and then together as a classroom, we talk about it. Maybe that sometimes asking more probing questions, getting the students' comments and reactions to it. And then towards the last 10 minutes, we all come together, we just have a debriefing and talk about last and final comments. And I think that it is a true highlight of the semester for many or most of the students, because it brings all of their learning together. It's like what they're learning in property matters to the economic and housing issues that we are currently facing. And I think students are also better suited to delve into and explore and to think about ideas of how to make a difference, and however it is the students see their own role as an advocate, because they have all of the tools. Not only do they have the law, which most law schools, especially your first year courses, focus on, they have historical context. They have personal narratives so that they understand what they're reading. It's not just about this case, it's about individuals and families and what largely African Americans were dealt with, and how its present day effect and how it leads to the lack of accumulation of wealth and sort of like this ideal or ideology around home ownership, and how many communities, especially the African American community of color, were pushed out, not by choice or personal decision, by direct policies and laws that were enacted over a 100-year period. So it really allows them to see and to feel the law in ways that you can't always capture, just in sometimes the limited time that you have in a class, or all the things that are happening. So I think that for all of our students, it is eye-opening. And then for some of our students that we're talking about the lived experiences of their ancestors or their grandparents or parents, it brings meaning and the feeling in a classroom that I am seen. We're not talking about this law in the vacuum when it's obvious that you're talking about my community. We're talking about my life and the way laws and policies impact that, both historically and present day. And I think that that enriches student learning. So I think about many of the laws that are pending or enacted, the notions of divisiveness or the discomfort, it just seems unworkable for me from a First Amendment perspective. It also seems somewhat ridiculous to me in sort of like what my goals are as an educator. I think about student discomfort. I think about, what's going to best make them learn, but it's never this idea of shutting off knowledge to my students. It's always thinking about how I can better convey understanding and knowledge and thinking and all the rest. And I think that my paper hopes to contest that notion, to first demystify what CRT is and what it could look like. This is not the only way it looks, but also this emphasis on like how important it is to learning. And that is what becomes divisive, because if we're unable to be empathetic or to understand one another, then we're polarized and we're stuck in our cacophonies of I agree with what I just said, but it doesn't allow for any learning or growth or policy making that is considerate of all perspectives. So, that's what I do. And as you can see, I tie it right into my learning outcomes, legal knowledge, of course, and cross-cultural competencies, because I set an expectation in all of my classes that all of this discussion will be meaningful and respectful, and that it will be evidence-based. My students sometimes make fun of me because I'm like, what are your feelings? I want to see what the evidence supports. Then we can talk about feelings, but I want to talk about assertions. I want to talk about evidence. So when I really get to the ICC discussion, this is my goal. And my students have seen this already, where I talk about, so Richard Rothstein's overall thesis and maybe his thesis within chapter 3, what is it, right? And then most importantly, where's the support for it, right? This is learning. And then what really gets some good conversation going is this notion of like, if you believe Richard Rothstein, right? What assumptions and values must you hold, right? That gets at the basis of any reasoning, right? So we have these wonderful conversations, and we can even do a back and forth for others that may hold a different ideology or perspective, right? And it sort of makes them question critically their own views and the views of others. And if I'm not doing that as an educator, I'm not sure what it is. And the thing that I want to know is that I don't teach property. I don't always teach the LCC class. So this truly is a collaborative process. It is not a high-tech process because this is how the notes look. One day I'll be fancy and use like some type of online version of this, but it is low-tech. So this is sort of how the classroom, one side of the classroom looks. And then up to the last, I want to leave you with some of the student responses, and I'll only focus on 2 questions. So we talk about a statement about Rich Rothstein, if young people are not taught, and an account of how we came to be segregated. The generational how will change and doing a better job of desegregating than the previous ones. And I asked for their thoughts, sort of an opener. And then I also asked, what's your most significant learning? And I've collected their responses. Maybe I hope to do some empirical work if I'm doing it right. And so here are a through line or a theme for many of the students' responses. So I hope you can read it, but the through line, many of the students in response to that first question, and I feel this in the classroom, it's both sadness and they're upset that what they are learning, and this is across the board. I have wonderful, smart students. They don't know American history. And they just have no idea. And they're just like, we've never learned this in this way. And that there's a sadness to that. And there's an anger to that. And I feel that many of the students feel that they've been disadvantaged. Like, how could I not know these things? And I'm in my first year of school. Then when others talk about how this has contributed to their learning, the through line there is this notion of like, I want to talk about these things, but I don't have the tools. Many of my students, and I teach here in Columbus, Ohio, many of my students are from outside of Columbus, which has varying levels of diversity, but this is something very new to them. And there's a lot of discomfort in talking about these issues, but they feel that as a result of this learning that really takes place over the spring term, sometimes through the full academic year, it provides a factual basis for doing so. Like, I can have this conversation in a meaningful way. I may not be able to get people to my point of view, but at least they'll see the point of view that I have. It also talks once again about this gap in learning and also this lack of accountability. And once we get to that point in the conversation, it becomes this notion of like, what can I do next? And so that's part of your professional identity formation about what are our action steps, what can I do? And then it's quite nice because, I don't teach property, I sometimes teach ICC. I teach CRT narratives, and I teach a Latinos in the Law course. And many of those students are there and they tell me because they want to learn more. So I've supervised papers now, seminar papers where the students are continuing on and they want to talk about, property law in particular, about how to effectuate change in what they see as a positive way. And for me to see that growth from all the learning and growth that takes place for a student when I see them in their first year to as a second or third year, and that connectivity and the desire to learn and to grow more is one of the biggest rewards I have from this work. So that is the parts of my paper. And so the thesis of the paper is just to contest this notion of this of CRT or any of this type of learning, no matter the label that you give it, it is somewhat divisive and harmful. I think it's the very opposite of that, in that if you ignore and if you outlaw and you prohibit this type of learning, it causes a tremendous amount of harm to all of our students. Not to have this as a pedagogical tool causes harm to the instructor, to the educator themselves. So that is my piece. Now it's my Q&A time. So I'll open the floor, I'll close my slides, and here's my contact information.
Thank you so much, Professor Molina, for that presentation. I can start first with the Q&A, and if anybody has any questions, they can feel free to unmute. So you mentioned in your last point, action steps, like students ask, what can they do next? And that is a really good point. Like, what can we do next? Is it like us going to our professors and speaking to them about the curriculum, or like what can we do as law school students?
Right, and you want to come up with the notion of collaboration and consensus building, and then you want to have your tools. So this is going to be another interesting piece, because like there's a point of tension, because you have certain states that are passing or have pending legislation that prevents us from doing this very work, or would hope to do so. But you also have an ABA standard, so like, we have to make sure we're following our standards. Professors and administrators, we have our rules too. And so the ABA, I think about a year or two ago, enacted that we are required, the we being law schools, are required to provide 2 educational experiences to our students. Now, one is at the start of your experience, so like within your first year, and it's training on bias, on racism, and on cultural competencies. Then it's supposed to happen again. And usually that's tied into before you go and do a clinical experience. You're also supposed to get this in professional responsibility. So I recommend that you learn and you do your literature review and you look at ABA standard 303. And so you say, I would like to have this conversation. Can we start to have a dialogue about what the school could be doing so that we can facilitate this type of learning? And by the way, I'm also aware of like the standard. Have you heard about it? They have. And that can just be sort of some leverage that you might have to talk about how to do these things. Might be one point of entry. So you come together, you coalesce with your fellow like-minded students, and then you talk about some of the things that you would like to see happen. Like think about, have some ideation about what this might look like, and then start speaking to faculty and to administration to see sort of where it is. So I'm happy to hear that CRT is offered. But there might be other opportunities that sometimes you're not aware of. There's so much going on in law school, and you might be pointed out like, hey, this is actually happening. Or you don't remember when we did this in first year, but this was happening in your first year, but there's so much happening in the first year. So it'd be a point of education and discussion for both you and for faculty and administrators.
Thank you for that. And I don't see any questions in the chat, but if you guys do have questions, you can always feel free to just put them in there. And I know it's 7:25, and I do want to give Professor Mitchell some time to also present. So if everyone doesn't mind, I will extend the symposium just for 15 to 20 minutes. If anybody has to hop off at that time, please feel free to do so. But I don't want to cut your Q&A short, Professor Molina. So does anybody have like a last question? Okay, so I will just move on, and then we will just, if there's any questions in the chat, I can always circle back. And I know, Professor Molina, you did leave your contact information, so you can all feel free to ask questions as well. So we will move on to our last panelist, Professor Mitchell.
Great, thank you. I appreciate it. I feel kind of left out. I didn't go to UCLA, and I feel not a part of the club. I mean, I just went to Penn. So, but actually, it's really a privilege to be engaging in this conversation. I came to this topic in 2 ways. The first is I sit on the Missouri State Advisory Committee to the U.S. Commission on Civil Rights. And so I raised it as a proposal of investigation for our committee to explore, for the U.S. Commission on Civil Rights to take a look at, to engage in this conversation about, in effect, that this is a civil rights violation. That if you infringe upon or you prohibit or prevent the teaching, it falls under that category and should be explored in that way. That's the first way. The second way I came about it is that I have a 10th grader and a 6th grader who are both in public schools. I have one who does debate and who talks about segregated military units. And I have another in friend groups, another student in friend groups, my child, and a number of them are questioning their sexual identity. And in both circumstances, with the current legislation, both of those things, the very academic debate and the very social engagement, would both be prohibited in their school settings and potentially be problematic with respect to how they navigate the space. So my paper sort of begins, or not begins from that, but that's sort of the impetus, if you will. So I'll start here. Quote, if you can control a man's thinking, you do not have to worry about his action. When you determine what a man shall think, you do not have to concern yourself about what he will do. If you make a man feel that he is inferior, you do not have to compel him to accept an inferior status, for he will seek it himself. If you make a man think that he is justly an outcast, you do not have to order him to the back door. He will go without being told, and if there is no back door, his very nature will demand one, right? That's Carter G. Woodson in The Miseducation of the Negro, right? Leaving aside the outdated language and the singular in terms of gender, I think it's very relevant to the notion of this prohibiting and preventing the teaching of certain materials. It's the very idea that it's changing the actual narrative of what we are teaching children, what we are teaching individuals in schools, such that we are conditioning them to a particular kind of behavior and future lifestyle. I think Professor Taifha said it too, right? If you control the youth, you are controlling the future. If you rewrite the narrative, then you are changing the critical analysis of individuals who will be graduating. So my paper begins from and looks at this context in sort of three phrases, the three parts, if you will. And so I use, and I think someone mentioned earlier about where they can find data about legislation. PEN America has an updated legislative site. They update all the time about laws that are being passed in this context. And they have framed these laws as educational gag orders, preventing teachers from engaging or talking about this. I look at it with three particular characteristics or three groups. So the first thing is this notion of, when we take a look at anti-woke legislation, right, we're talking about this being impermissibly infringing upon the civil rights of three particular groups: students, parents, and their teachers, each of whom have a stake, if you will, in this notion of not preventing or opposing this particular legislation. And so the paper actually addresses this in the following way. So part one of the paper says, fundamental public education, which is not a fundamental right, should have more than rational basis review as its frame of analysis. Right? And it goes back to, quite frankly, the language of, and I think Joseph mentioned Brown versus Board, right, where they talk about, quote, today education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities. Right? There is clearly a premium placed upon education, but we don't give it fundamental right status. Right? We actually give it status in that regard if you look at cases like Plyler versus Doe or other places educating undocumented minors or other areas, but not in the actual provision thereof of the substance or the material itself. Right? And so here, the first notion is, quite frankly, this should not be, while it's not going to get fundamental right status, it doesn't have it, it certainly shouldn't be rational review. And basically what might be better for, if we're going to look at this, is heightened scrutiny. Right? Given the nature of who is directly impacted, gender, sexual orientation, gender identity, right? If we're not going to give it strict scrutiny based upon race, if you look at all of the groups that are currently being attacked and targeted, it should fall under a higher level of degree of scrutiny with respect to the analysis of its deprivation, of its denial, right? Now, that's that very sort of, got to have the legal argument in there, right? That's my sort of, hey, let's talk about scrutiny and process. All right. Moving that aside, I think the next thing is, in my article, right, in part two, is actually taking a look at the terms that are being used. So I look at divisive concepts, I look at anti-woke legislation, and then look at CRT and 1619 Project, and also DEI. And so the first two, I think, divisive concepts and anti-woke legislation, are so broad. They are catch-all to basically capture everything. Someone also mentioned Christopher Rufo. The quote that Christopher Rufo says in his interviews with Tucker Carlson in the New York Times, it is very explicit. The interviews say, I have latched onto this phrase, CRT, and these other phrases to create a political response by the ideological right. And it's very blatant. There's nothing to do with the substance, nothing to do with the value of it, but it is solely to move a population of individuals to adopt, if you will, a perspective and something by which to galvanize a political movement. Not about substance, not about content. So the first thing is defining this, right? And I go back to the executive order and using that language to talk about that very vague and broad language, which is so amorphous that it actually covers things from the book about Ruby Bridges. It covers Rosa Parks. It covers actual facts of American history as being areas and topics and material that might be fundamentally problematic because it creates a quote unquote feeling that one student or another is inferior, and it creates in a particular student a sense of, if you will, angst and anxiety and frustration and guilt about the actions of their ancestors. The anti-woke legislation, the anti-woke terming and phrase, quite frankly, is a stolen word. When we talk about wokeness, right? Wokeness was about, in effect, to young Black consciousness and activists, stay woke, be woke, right? The idea was that, oh, you need to recognize the fact that you need to identify systemic structures and powers and address them and continually fight against them. It's been co-opted. And so now everything that deals with social justice or framing is now anti-wokeness, right? So the co-optation of a word that was once a very positive one is now pejorative in a very negative way. The other two, CRT and 1619 project. So CRT, as one who actually does CRT in law schools, you think about how did this theory arise from all these other theories in law schools that deal with marginalized folks? I teach a class on law and society. We talk about this, and I wonder, no one went after queer theory, no one went after lat crit, no one went after feminist jurisprudence, and yet critical race theory rose to the top. Why? Because it's the third rail in American history, right? Race. Because it deals with race, because it deals with structures of power, and because, I think Professor Taifha said, because it came in the aftermath of the summer of unrest, that now this becomes this issue, right? Now it becomes a part of this mantra. When Black Lives Matter is mentioned, so is CRT, right? And so you have those issues. And then for the 1619 project, we see the counter narrative being the 1776 project, right? The idea that we have to untarnish, if you will, the founding fathers, that we have to basically restore the narrative of this history where individuals did not engage in this kind of attitude or behavior. The last one, which I find problematic and that has also been used in this context, we're talking about anti-woke legislation in the classrooms, is DEI. Because it is so broad and it's so misused and it deals with trainings and workshops, that there's a conflation of the fact that divisive, anti-woke, CRT, 1619, while there may be elements that we pull from those areas to talk in a DEI context, DEI is not a class that is taught, right? We don't teach diversity, equity, inclusion. We may practice it, we may encourage our students to do so, but this is the problem. And so the issue is that there's a conflation of curricular concepts as well as non-curricular concepts, so that the waters are all muddy. So the first thing is that we have to unmuddy the waters and figure this out. All right. Now, getting to the meat of the matter, which is whose rights are at issue here? Students, parents, and teachers. And so the first thing is the idea here is that students have a right to learn, right? Have a right to learn certain materials, and we are infringing upon this. But when we look at this at the first iteration of how these laws are being put out, the states themselves are in effect eclipsing what they have done traditionally. They are overstepping their bounds in the delegation of their authority to agencies and local school boards. So at the state level, these laws, this legislation is infringing upon what they have set up as the framework for how curriculum is to be decided. So one, they are stepping in the place of local school boards and communities to create their own curriculums, right? So that's the first problem, at least with respect to the states. The second thing in that framing is that local school boards that are endorsing a specific view are engaging what the court talks about is this pall of orthodoxy, right? This is the Keyshawn versus Board of Regents case, in which the court says basically you are elevating a particular framework over all others. And so the idea that you are preventing this kind of education, you are inserting a different kind of educational framework. That's the pall of orthodoxy with respect to a very particular case. Now, that case dealt with universities, higher education, but the same views apply to K through 12 in this context. The last thing is, of course, is this infringement on students. So the first, the infringement is on the right to learn, a First and 14th Amendment issue with students, and they have the right to learn certain material. The second goes to the issue of parents being able to direct the education of their children. The same argument that adherents and supporters of the legislation are used are being overlooked on the other side of the aisle. The idea here is you are allowing a group of parents to determine and decide what my child should learn when you just said what I have indicated is enforcing that upon you. But now you're privileging it through state legislation, the rights of these particular parents over my own, right? And so that is the competing conflict, the contestation, if you will. The last thing, of course, deals with teachers in K through 12, teachers who have less academic freedom than, if you will, teachers in higher ed. But it combines with the other issues of students and teachers in the fact that teachers are engaging in their self-censorship. Teachers do not know what the landscape looks like as to what is permissible and what is not permissible. And the problem is not that they are, one of the problems, of course, is that they are engaging in self-censorship. The other problem is if they violate those rules, they are in jeopardy of, one, potentially costing financial penalties for their school districts, and two, losing their jobs. So the self-censorship process is such that no one wants to engage in a topic that may even be in line with what the statutes say are permissible for fear of overstepping their boundaries. And so what we see is that this prevention, if you will, of teaching quote unquote this material, this curriculum subject, is that now we create a class-based assessment in schools in the sense of the following. If I have a child and I am a law professor, right, and my spouse is a law professor, we're both college educated, my children will learn this material, but that's therefore class-based potentially. Unless there are other avenues and resources for other students in a public educational school setting to learn this, we are now creating a divided class, right, in that sense. The last thing I will say is we have seen in the past other remedies, if you will, with respect to materials that folks didn't want to learn, right? The great opt-out provisions. And we see that in health education, in sex education. Oh, you don't want to learn about this? Your child can opt out. The problem with these curricular provisions and prohibitions is you can't opt in. If the school bars the teaching of this material, what does the opt-in provision look like? There's no such thing. You can't have an opt-in provision. So one, this prevents students from actually learning what we allow other students to opt out of in other circumstances, so they can't get this. But the other piece is, and this is a scholar who we had as one of the hearings for the MOSAC committee, talked about that the opt-out would be unfeasible. Can you imagine teaching a history course and every time you came to a topic that somehow raised a potential guilt or talked about race or talked about gender or talked about gender identity, that a student could opt out, you would fundamentally have a classroom where students would be leaving on a regular basis, right? But more importantly, it goes back to the initial issue of the value of education. We are teaching students to be ready for a workforce and a global economy. Not giving this information is quite frankly a disservice to those students, not just the ones who want to learn it, but those who also don't want to learn it, but need to learn it as well. And so the last thing I would say to that is, what we have is, with these particular provisions, it's a resurrection of an orthodoxy of exclusion and intolerance and inferiority that existed prior to the expansiveness and inclusion, if you will, of the current curriculum, right? The current curriculum now is what universal suffrage looks like. The old curriculum looks like what suffrage was before we had, if you will, the right to vote being extended to everybody else. And the last thing I will say is this, the other analogy I like to use in this following circumstance is, for those who in the criminal justice context, right, we talk about stand your ground laws, and the case that I always like to mention is Trayvon Martin, right? People talk about stand your ground for Zimmerman, but no one talks about stand your ground for Trayvon Martin. We talk about the rights of parents here for parents who want to oppose the teaching of such material, but we never raise the case of parents who want their children to learn this material, right? Because it's the existing framework. And so at the end of the day, the wokeism, right, which is false, a political movement, not really about substance, goes to the heart of the matter of what children should be entitled to learn using a framework is a civil rights violation and should be sort of, if you will, should be what we're sort of striving towards. So.
Thank you so much. Thank you so much, Professor Mitchell.
Sure.
I will open it up for Q&A for about 5 minutes. So Alex, yeah, you can start.
Thank you for extending this, by the way. Thank you for everybody for staying on after 7:30. Professor Mitchell, I just wanted to compliment the subject matter of your work. It's very similar to the scholarly note that I wrote last, where I was almost a year ago now. I was going to say last semester. But I wrote about the Don't Say Gay bill in Florida. And I know that you mentioned a lot of people argue on either First or 14th Amendment grounds that laws like that are unconstitutional. I instead, because I thought that the topic was probably taken in that realm, argued that it was a violation of Title IX for, students and teachers. And I think it's really important that you point out that this type of legislation, it creates a chilling effect, whether it's teachers, losing their licenses, losing their jobs. Sometimes these laws like the Don't Say Gay bill can create a cause of action against the school districts. So that oftentimes the schools are saying to teachers, school personnel are saying, you can't, just don't bring up anything even close to that, because as you said, it's really the, I guess the strictest, or I don't know, I guess I'll just say go with strictest, but strictest parents who kind of dictate what happens in the classrooms. So I just think, I'm more so because I'm like really interested in this particular area of law, just because I was, I've written about it. Obviously you can articulate it a bit better than I can. But I think that for everybody listening, this is like a really important, and like I mentioned at the beginning, it's very rapidly developing, and the implication on children across the country is huge. So I just wanted to thank you. I don't really have a question, but I just want to stress the importance of what you just described and what all the panelists have been speaking about, this whole night. So
yeah, I think actually there's a very interesting fact about the number of parents who actually are leading the cause for book banning, right? And they talk about this as being this small number of parents who are actually leading this charge for book banning. And that's kind of, and that's actually very frightening, right? That it's a really small percentage of individuals, not a small percentage, a small number, right?
Right, very small. And it's I know the group like Moms for Liberty.
Yeah, that's right.
I'm sure you were aware, but yes, you're absolutely right that it's a very, very small contingent that's dictating all of this. I see Noah has a question, so I'll lower my hand and allow Noah to speak. And no, I think you're still on mute, by the way.
I can't hear Noah. Noah, if you wanted to chat your question in the chat, I can read it. But after Noah, we will wrap it up. And I actually have a question. In the meantime, you mentioned I didn't really realize how broad the divisive concepts were. I didn't know like it included things like Ruby Bridges, because I remember in elementary school, I literally like watched that movie every single year. Like they like all the students watch that watch that movie. So I just wanted to know, what effects do you like anticipate there being in the long run if teachers or schools refuse to teach topics like this, like Ruby Bridges and other like really important things in US history? How will students get to see the full picture of the US history?
Yeah, I mean, quite simply, they won't. I think the very idea that if you allow for either the book banning issue with respect to removing those books, or the teaching of certain topics, or the feelings of issues of guilt, right? The moment you sort of inject feeling of guilt, I mean, we should all feel guilty about America's past history, but those ancestors who owned slaves, and maybe there should be some more guilt felt, right? I'm not saying as though, I mean, why shouldn't there be that context? I mean, we would never tell someone in Nazi Germany, right, that, hey, you shouldn't feel guilty about the Holocaust. Yeah, you probably should, right? And so we think about this sort of protective notion of creating this bubble around children, when quite frankly, this is America's reality. But we want to keep it as this gilded reality, right? And we want to absolve the founding fathers, right? And we want to absolve the past for what were some horrendous acts, right? And quite frankly, I mean, if we look at it, even sort of as lawyers, right? It wasn't like we had a great sort of face and perspective during internment, right? And Japanese internment, right? So when we look at many of the foibles that we've had, that's a part of who we are as a country. And to not know that means to repeat that, right? And that's where I think the problem is. And this is where I think the class issue becomes, right? Because I consider myself, when I was growing up, you consider talking about individuals who had to learn about Black authors and writers because they weren't being taught in school from parents who were actually very forward thinking, right? That you didn't get Toni Morrison unless your parents were like, you're going to read Toni Morrison. Now we have it, and now we want to get rid of it again, right? And so it's this notion of creating a whitewashed version, a sanitized version of American history.
Thank you. And Lauren, I see you have your hand up, so you will be the last question, and then we can wrap up the symposium.
Sorry, really quickly. I know like one of the first things you said was you talked about how students have a right to their education. And I know that the Supreme Court has like constantly denied giving them a fundamental right to education. And so I wrote a note with a similar topic and I argued the same things. And I talked about a recent case. It was in a district court, but the court said that students have a right to learn and receive information. And so I wanted to know if you think that is going to go anywhere, or maybe, you know, and if it got to the Supreme Court, do you think they would strike it down, or if you think maybe we can build off of that in the future?
Yeah, I mean, I'm a New Yorker by actually growing up. I grew up in New York, so I'm a pessimist by heart, at training. I don't think the court, quite frankly, is going to change its perspective, and I definitely don't think this court is going to change its perspective with respect to whether education is a fundamental right. Right? I mean, there is no way that this court's going to actually change course. Which is why I think Alex mentioned in his own paper, right? The idea here is there has to be other legal avenues in order for us to challenge this, right? And we look at other, and this is where you look at, I think, education as a human right. This is where you look at education as something more than, in effect, just going to school. And if you frame it as, well, we have compulsory education for a reason. Well, if it's compulsory, then it has to be more, then we have to do more than what it is, right? Particularly right now, if we're giving all this license to families to homeschool, to pay for kids to go to religious schools. Well, if that's the case, then dictating, in effect, what the curriculum should look like in a public school setting, right, should not be driven by this minority of individuals. And this is where, right, the minority shouldn't be the tyranny here in this context. But do I think the court's going to actually move and make it fundamental right? No, certainly not in my lifetime.
Thank you so much, Professor Mitchell. And thank you to all the panelists who participated tonight. This is the conclusion of our symposium. I just want to thank all 5 of you for taking out the time out of your busy schedule just to speak about these relevant issues today and provide such insightful discussion. I learned so much and I really enjoyed it, and I know everyone can say the same. And just thank you so much to all the attendees, for your attentive listening and your participation and thoughtful questions tonight. I really do appreciate it. And thank you to all of our JCRED members who worked on editing these papers, which will be published in our upcoming issue. Thank you, Professor Chu and Professor Costello, who are our faculty advisors, for overseeing this event. And last but not least, I just want to thank the marketing department, the IT department, student services, the special events team, and alumni relations for making this event a success. Have a great night, everyone, and thank you all so much for coming out.
Thank you, guys.
Thank you.
Thank you. It was really great.
Thank you, everyone. Have a good night.